bana. Ukiwa sisi wenyewe tukoka hatuwezi sikia. Mzee.
Usiria jambo.
Usalama. Dere. Hiyo kelele inaumiza watu bana.
Nashukuru pole mda.
Mimi mwenyewe nimesimama huko hata siwezi nini.
Pole mda. Tatu pige. Merry Christmas lakini.
Sawa, lakini mpunguze tu kelele. Sawa. Ngoja maliza panga kwanza munione.
So I had a headache. Like a headache, this headache whereby you can't even look straight. I get into a matatu and the matatus are playing loud music. It's not music, it was loud noise. Because music is organized sound. Now, this was very disorganized sound. Because the sound was bad. You know, like that, as if like that sound whereby, I don't, like, you know, speakers that, as if there is a cockroach inside, and the music is like tears started rolling down.
A Nairobi lawyer has petitioned the High Court seeking to outlaw the playing of loud, unsolicited music in public service vehicles, arguing that the practice violates the constitutional rights of commuters. Advocate Samwel Barongo Nyamari has filed a petition against the Matatu Owners Association, the National Transport and Safety Authority, the National Environmental Management Authority, and the Attorney General, asking the court to compel authorities to curb excessive noise in matatus. The case came before Justice Patricia Nyaundi at the Milimani Law Courts, where Nyamari argued that thousands of passengers are routinely subjected to loud music during their commutes without their knowledge, consent, or the option to opt out. In his petition, the lawyer contends that the practice infringes on several constitutional guarantees, including the right to human dignity, the right to privacy, and the right to a clean and healthy environment. He argues that commuters should be able to travel in public service vehicles without being forced to endure excessive noise. Nyamari is asking the court to determine whether matatu operators can lawfully play loud music throughout a journey without passengers' consent, and whether such conduct is compatible with the Constitution. Following preliminary proceedings, Justice Nyaundi directed all parties to file and exchange their written submissions before the matter is set down for judgment. The court is expected to deliver its judgment on April 29, 2027.
What I term as a pandemic that has been going on in this country. A pandemic that has been perpetrated for a long period of time by the matatus in this country, specifically in this city of Nairobi. Yona, I won't take much of your time, because much of the arguments are in my written submissions. But what I wanted this court to understand is to have a perspective on this matter, to understand the seriousness of this petition, so that, my lady, as you retire to consider your submissions, I believe your work will be made easier. Now, the summary of my case can be limited to three main arguments. Number one, leading, is that the Constitution highlights a commitment we made as a country to protect the well-being of every citizen of this country. The well-being of every citizen of every community. And under the concept of the well-being of every individual, you have the right to the highest attainable standard of health under Article 42. It is my humble submission that the failure by the second, third, and fourth respondent to act on the menace that is the loud music in matatus, the failure by the respondents to act on these menace has caused many Kenyans trouble, harm to their well-being, my lady. My lady, I invite this court to take judicial notice of the fact that many matatus play loud music all through without regard to the nature of passengers they're carrying. Play loud music to the young, tender babies, to the old, to the sick. My lady, you cannot even take a call. And in particular, the NEMA, the National Environmental Management Authority, the only thing it has done is to publish regulations. It has done nothing proactively to curb these menace. And there's a prayer, I'll be praying for a structural interdict, a prayer in the nature of a structural interdict, as exposed in the case of Matatu, to compel the respondents to act on these means. And finally, lady, I brought this petition also in my personal capacity, as I have suffered from this menace for over 6 years, and I'll be praying this court to award me damages for the harm that I've suffered in the interest of justice. Also noting that I've not brought this petition merely as an academic exercise. I've been affected by these menace over the years. And finally, Lorna, as I conclude, I think it is important for such cases to be heard in open court, because the public needs to understand what went on before outcomes are made. It makes compliance easier when the public participates in such cases that are filed in public interest, in such cases that affect the public at large. That will be the end of the submissions. I invite the court to go through my written submissions, which highlight now the arguments in depth. Thank you, my lady.
Dated on 9th of June 2026, and our submissions are dated 13th July 2026. We wish to wholly adopt those submissions. I believe they are very comprehensive and they are responsive to the issues raised by the petitioner. Thank you. Good morning, my lady. Ms. Litoro, for the court respondent.
Good morning.